Out of Order Gun Rights Podcast, Episode 57.
Welcome to the Out of Order Podcast, your window into the firearms community, exploring those shaping the future of our rights and protecting our lifestyle, laws, legal cases, activism, and self-defense in a candid and honest podcast for our brothers and sisters in arms. Here's your host, James Kalita.
Thanks for tuning in to episode 57 of the Out of Order Gun Rights Podcast. Today's sponsor is the Out of Order Gun Rights Podcast. If you head over to the show notes page, outoforderjameskalita.com/57, you'll see links to our sponsors, and we've created a new Patreon program where supporters contributing $5 or more per month get exclusive access to our members-only Facebook group and a personalized thank you message on the show. Today's guest is Joshua Prince. Joshua is Chief Legal Counsel for the Firearms Industry Consulting Group and a prominent attorney in Pennsylvania. And now, here's Joshua Prince.
Joshua Prince, welcome to the show.
Hi, thanks for having me, James.
Oh, my pleasure. So, Joshua, you are a firearms attorney in Pennsylvania. Would you tell us a little bit about your work?
Sure. I handle any state law issues in Pennsylvania and Maryland across both states, and any federal issues I handle across the United States. I also deal with some international issues regarding the import-export of firearms. At the state level, my firearms practice involves everything from representing individuals who are erroneously denied by the Pennsylvania State Police or the Maryland State Police in relation to purchasing or transferring firearms or ammunition. I also represent a bunch of gun ranges dealing with issues with everything from bylaws specific to being a gun range to escapement issues if a round leaves the property. We also represent a bunch of federal firearms licensees, which most of your listeners probably know as gun dealers, both in Maryland, Pennsylvania, and then federally if they have issues with the Bureau of Alcohol, Tobacco, Firearms, and Explosives. We handle those federal issues across the U.S., and those could be anything from record-keeping issues to the fact that they've developed a new product and they need a determination as to whether or not it constitutes a firearm or what part of the new item constitutes the registered part, if it is going to actually be a firearm. So it's really interesting. It takes me into many areas of the law. We can have contractual issues. Also at the state level, it involves individuals who are involved in self-defense situational shootings. So whether it was justified, whether, at least here in Pennsylvania, our stand your ground doctrine applies, or potentially castle doctrine if they're in their home or in their car. So it's always something different, and I absolutely love it.
Oh, excellent. And you touched on a lot of things there, and I think a lot of people have this idea that if they're not doing something wrong, they really don't need an attorney. But like you mentioned, working with FFLs, if they're really working by the books or trying to, do they need a lawyer? I think a lot of people might hear that and think they only need a lawyer if they're selling illegal guns to gang members or.
Unfortunately, the laws are so complex when you also include in the regulations that many of them innocently end up violating a regulation or not fully understanding what a particular law or regulation requires. So we do what we call mock compliance inspections, where we'll go into an FFL's business and basically perform the type of compliance inspection that ATF would do when they come out. The benefit of having a law firm do it is that any of our findings are protected by attorney-client privilege work product. We could not be subpoenaed and forced to disclose our findings in any court, and that is a way in which we can identify problems and get them resolved so that the FFL doesn't have issues in the future with ATF. So we do a lot of that, and also, as I said, they may have developed a new product that they need to determine whether it constitutes a firearm or not. Or they may have an unusual situation where they need to get a determination from ATF as to whether certain conduct is lawful. A good example was, I guess now probably about a year and a half ago, I represented Trop Gun Shop, and they authorized me to disclose this publicly. They have an indoor gun range, and they wanted to determine if they could lawfully rent a handgun and ammunition to someone who was between the ages of 18 and 21, because federal law generally precludes the sale by a federal firearms licensee of a handgun or handgun ammunition to someone who's under the age of 21. I had reached out, wrote an extensive request to ATF explaining the law, explaining past determinations they had made, and why, in my opinion, I believed it was lawful for Trop Gun Shop to be able to rent a handgun on premise with ammunition without violating the law, provided that the handgun and ammunition never left the premises, and ATF agreed. So that was one of those areas where the law wasn't explicit, and we wanted to ensure that my client's conduct would be lawful, so we reached out to ATF to get that determination.
And I think a lot of people have this idea that, the Second Amendment protects them, especially in Pennsylvania, because we have that very strong worded message in our Constitution. But these laws get passed anyway. Do you have any, and then we live under them for a long time. Do you have any insights into how that happens and why that happens and what people can do?
Well, I guess first and foremost, I'll state that I don't believe any constitution gives rights. I believe that it's the listing of inalienable rights that are just being acknowledged in the U.S. and Pennsylvania constitutions. I think it's interesting when you look in Pennsylvania's Constitution in Article 1, Section 25, it actually states that all of the provisions of Article 1 are inviolate and cannot be basically controlled, limited, or otherwise changed by the General Assembly or anyone else in Pennsylvania. Now, the courts have obviously interpreted the Second Amendment provision of Pennsylvania's Constitution, which is Article 1, Section 21, to be limited, even though we have very broad language, more broad than that which you find in the Second Amendment. And so we live in this situation where the courts basically attempt to legislate from the bench and restrict rights by simply saying, all we're doing is interpreting what the original right as specified by the members of, or I should say the residents of Pennsylvania when the Constitution was ratified, or at least that particular provision. So it's very disconcerting to me that we see this type of attack on constitutional rights at both the state and federal level, but it is the framework under which we have to fight our fight. And we've seen a number of recent proposals and such which would clearly violate numerous different rights, both under Pennsylvania's Constitution as well as the U.S. Constitution. Everything from ATF's rulemaking regarding bump stocks, where they are seeking to basically turn all bump stocks overnight into contraband and force individuals to destroy them or turn them into the government without the government paying any form of just compensation, which is a violation of the U.S. Constitution as well as the Pennsylvania Constitution. So that's just one example of the types of issues that we're seeing. We have been successful in some Second Amendment type litigation that's still in what I would call its infancy. Those are what I call, or what the courts call, Second Amendment as applied challenges. These are limited constitutional challenges as applied to the particular plaintiffs in that particular matter. So unlike a general Second Amendment type case, which would be a facial challenge arguing that in no circumstance could this be constitutional, with an as-applied challenge, you're only arguing as it relates to the particular plaintiffs in that case, can this law or restriction be constitutional? And I've won several Second Amendment as-applied challenges here in Pennsylvania. Two were in relation to mental health commitments, where the court found that it was unconstitutional to deny those two plaintiffs for the remainder of their lives because of a decades-old involuntary mental health commitment. We've also recently fought a Second Amendment case where we argued that a 302 involuntary commitment here in Pennsylvania under the Mental Health and Procedures Act was not sufficient to strip someone of their Second Amendment rights because of the lack of due process. And in December of the past year, Judge Gibson of the Western District Court agreed with us and found that my client was not prohibited because he was only 302'd. I have a number of other Second Amendment as-applied challenges currently pending that we're waiting for decisions on, such as individuals who were convicted of a DUI that now prohibits them for the remainder of their life from being able to purchase or possess firearms when no one was harmed as a result of that DUI, there was no property damage, nothing like that. That's not me condoning individuals driving under the influence of alcohol, but rather it is difficult for me to comprehend how we strip someone of a constitutional right for the remainder of their life, but we do not strip that person's ability to obtain the privilege of a driver's license for the remainder of his or her life, or strip that person's right to purchase a vehicle. So in those cases, we're trying to argue because of the nonviolent nature of these offenses and the offenses being graded as a misdemeanor, that it's unconstitutional to deny at least that particular plaintiff for the remainder of his life. We also have an individual who is prohibited because of a forgery conviction. Where, again, no one was harmed, and we're basically arguing that that's unconstitutional to deny him for the remainder of his life the ability to purchase and possess firearms. So it's really an area of the law that's at its infancy, and we're going to have to slowly develop it, hopefully in our favor. I know some people have brought challenges that, in my own opinion, would have no possibility of being successful, and I believe in bringing those types of challenges, it only hurts other individuals who may have legitimate claims, because we really need a foundation of positive case law before we start going to those extremes. Unfortunately, few individuals and few attorneys understand that.
Sure, and you're going through these cases for the people that you're representing. What does their life look like while you're going through this process? I think we see shows on TV and we think everything's handled in 45 minutes or one session, but is it months or years or?
Usually anymore, it's now years. The way in which the government has been litigating these, and just so everyone's clear, we're suing the U.S. government. So usually I'm suing ATF, FBI, the Attorney General, and the United States government formally. And as I'm sure your listeners are aware, they have all the attorneys at their disposal that they could want to litigate these cases. Initially, in what I'll call the first wave of these types of challenges, the government felt there was no way possible it could lose these cases. And so the way in which they handled them is you would file the complaint. You would then have to serve the complaint on the different U.S. government entities. They have 60 days from the date of receipt of it to file an answer. Usually, instead of filing an answer, they'd file a motion to dismiss, and in the alternative, a motion for summary judgment, meaning there's no legal or there's no factual dispute. The only one is a legal dispute, and that they felt they were entitled to relief or a determination in their favor on the legal issues. Those were extremely streamlined, and those generally yielded a decision within 8 months to a year, depending on how busy the judge's docket was. As the U.S. government started losing those cases, they started then developing a different strategy whereby now they may still file a motion to dismiss initially. It's going to depend on the factual underpinnings of the case, but more frequently they file an answer, and then they want full-blown discovery. And I can tell you I've been absolutely astonished now at the length they are going to in discovery. I've had a client, as I mentioned, who has a DUI. They have actually gone to the level of submitting subpoenas to every establishment in a 15-mile radius that sells alcohol to see if he's recently purchased alcohol. They will want to do depositions of the individual. If that individual is married, they may very well want to depose his or her wife or husband. They will want to go through all the medical records, even though the basis for the challenge may not involve a medical condition, it may not involve an involuntary commitment, it may not involve someone being addicted to drugs, but they will want to get that individual's medical records since they were born, which I think is absolutely abhorrent because there is no prohibition in the law in that regard. If the person had been involuntarily committed, the U.S. government would know that because in Pennsylvania all of that information is reported to FBI and included in the NICS database, which is the National Instant Check System database. So they know about that, but they will try to get any information possible to try and basically convince a court to deny a particular case. So someone who is a good candidate needs to be aware that basically the U.S. government's going to try and come in and analyze their entire life under a microscope, and they need to be prepared for that type of litigation. And it gets extremely costly because, once again, the U.S. government has all the attorneys it wants at its disposal.
And you also do something with the cannabis industry law group. I think at least once or twice a day, someone on my Facebook feed shares that Forbes article. Is there, or how do you see the future going for people that want to exercise both rights? Any hope?
Well, yep. Right now, I know there's a lot of misinformation out there. A lot of people want you to believe, even some attorneys, that because Pennsylvania has a medical marijuana program, it's okay for you to be able to possess a firearm, ammunition, and marijuana. Unfortunately, marijuana is still a prohibited drug under federal law. It is a Schedule I drug, meaning that it cannot even be prescribed legally by a doctor. And so an individual is prohibited under federal law from utilizing marijuana and possessing or even purchasing firearms and ammunition. That's just what the law says. Now, I think in the future we may see some cases challenging it. There have already been some cases challenging it where the courts have come out and said, I'm sorry, this is a constitutional restriction because of the fact that marijuana is currently a Schedule I drug, and we believe that your proper recourse is to petition your representatives to deschedule it or have DEA deschedule it. I think in the near future we will see DEA or possibly the Congress take action to deschedule marijuana. Whether it will be completely unscheduled or whether it'll merely be descheduled to a Schedule II or Schedule III drug is yet to be seen. But if it does become descheduled, even just to a Schedule II drug, at that point in time, a doctor could prescribe it, and then as long as an individual has a prescription from a doctor for it, it would be lawful for them to utilize marijuana and be in possession of firearms and ammunition. I know some states now are allowing recreational use of marijuana. In those states, if the U.S. government would deschedule it, let's say to a Schedule II drug, those individuals who are recreationally using it would be prohibited under law because they would not have a prescription for it. So we're going to really have to wait and see what occurs at the federal level in relation to marijuana. But as we sit here today, I can tell anyone that if you do have marijuana or you are using marijuana, or ATF, FBI even take the position, if you've utilized marijuana in the past year, you are prohibited from purchasing, possessing, utilizing firearms and ammunition.
And even that last part about having used it in the past year, that's got to be something that you could really get yourself wrapped up in. Because even though the burden of proof, I think, would be on them, just the accusation could have you without your firearms rights and under indictment for several years.
Yes, and that's one of the big issues And to be clear for all your listeners, there is nothing in the statutory law or regulation to support this position by ATF and FBI. They have made it up out of whole cloth. You won't find any mention of this 1 year restriction anywhere. But what FBI has been doing for the past number of years is saying if you are charged with a marijuana-related offense, regardless of the outcome of it, even if you're not convicted, you are prohibited for a 1 year period from the date you're charged. If then you are convicted of a marijuana-related offense, you are now prohibited additionally for a 1 year period from the date of conviction. All of this, regardless of the fact that the Third Circuit Court of Appeals, which is the federal appellate court that covers Pennsylvania, previously ruled that an individual, even being charged and convicted on one isolated occasion in relation to possession or use of marijuana, is not sufficient to trigger a disability under federal law, because a single isolated use is not enough in and of itself to show that the person is a user of. And they said that a user has to be someone, or someone who's addicted to, has to be someone who is utilizing that drug on more than one occasion. But the ATF and FBI believe they're above the law, and they don't have to comport their conduct with prior determinations issued by the Third Circuit.
So I always ask my guests, there are books they recommend for gun owners that every gun owner should read. Any come to mind?
Well, one of the biggest, I guess, concerns I'd raise is there's a lot of misinformation out there. So really be careful in selecting any books. I know recently there's one or two companies that have put out books allegedly in relation to Pennsylvania's firearms laws. I speak with individuals who unfortunately have read those books, relied on them, and then end up being prosecuted because the information in the book or that was relayed at a seminar was improper or incorrect. So I always advise people, make sure that you go out and you vet any attorney that you're seeking information from. Make sure that they really know what they're talking about. Make sure it's an attorney. Make sure it's not some former law enforcement officer, state trooper, or otherwise that's conducting the seminars. We've seen a lot of that recently where, again, they're giving out misinformation because they don't understand the laws. Quite honestly, there's probably maybe a half a dozen, if that, attorneys in the Commonwealth of Pennsylvania that actually understand all the state and federal firearms law issues at play and the interplay between them. So I really can't caution people enough. I actually this Saturday have a firearms law seminar coming up that I conduct at King Shooter Supply, and those are generally 4 hours long, and we don't even get through all the materials I like to cover during those seminars in 4 hours, and quite honestly, we probably only go over maybe 50 to 60% of the laws that are applied generally to individuals or that they may find themselves involved in during that period. There are that many laws and regulations that come into play that people really need to know about and be cognizant of, because I speak with clients every single day who pled guilty to a misdemeanor offense where they ask their attorney, is this going to prohibit me? And the attorney usually will say, oh, no, it's only a misdemeanor, you don't have to worry about it. Or they'll simply look to state law, and quite honestly, state law is far more forgiving in relation to what constitutes a prohibited person than federal law. And so they look to state law, say, oh, no, this is not a specified offense, you won't be prohibited. Meanwhile, the individual is going to end up becoming a prohibited person under federal law. So we've had a lot of situations like that. We've even had judges incorrectly advise individuals, and they weren't our clients, but later came to us because they said, well, the judge on the record said once I was done probation, I was okay. I ended probation. The court terminated my probation. I went to purchase a gun, and now I'm being prosecuted for making a false statement because they're contending that I lied on the form when I attempted to purchase. And it's at that point in time where we, try to get a copy of the transcript from the court proceeding, and a couple times now, exactly what our clients told us is what occurred. The judge says on the record, once you're done probation, you're good to go. But that's because the judge never considered federal law. And a lot of people are surprised to learn that misdemeanor offenses can prohibit you for the remainder of your life. So you need to really be aware of all that and make sure that any information you're receiving is good advice. We had a client who it was maybe a year and a half ago now, had contacted his workers' compensation attorney to ask his workers' comp attorney if his prior conviction would prohibit him. The workers' comp attorney looked in the Uniform Firearms Act of Pennsylvania and said, nope, it's not a prohibiting offense. Never looked at federal law. Well, he goes out, attempts to purchase a gun, and gets denied, and next thing he knows, he's being prosecuted. Luckily, that attorney was willing to fully acknowledge that he told him that he would not be a prohibited person, and he issued a letter to the district attorney stating that, and the district attorney then said, okay, I'm going to dismiss the charges of you making a false statement. But you need to understand it doesn't change the fact that you are a prohibited person and you cannot purchase or possess any firearms or ammunition.
Wow. And so do you have an opinion on the different insurances that are out there? I mean, should someone have them if they carry a gun for self-defense? And if not, how much should they really be nesting away, to cover a legal defense if they do need to use a firearms defensively?
I highly recommend that individuals have some form of either insurance or prepaid legal available to them if they are involved in a self-defense situational shooting. I don't endorse any one particular provider. I always disclose to people that a couple years ago, United States Concealed Carry Association, USCCA, asked me to be on their legal advisory board. They were seeking 12 attorneys from across the United States to advise them. I agreed. I am still on their board. But even given that, I still don't endorse any one particular provider. I will say, in my experience, USCCA has been exceptional. They pay very quick when an individual is involved in a situation. That includes getting money for bail. That includes getting an attorney paid, getting preliminary reports. And because of the fact that they have that money immediately available to me, has allowed me to be able to get experts involved immediately. In fact, in one case in Lancaster County, it was all caught on video. And it was clear my client didn't even discharge his firearm. And in my legal opinion, he was authorized to discharge his firearm and kill the other individual. He did not. And even given that, the police officer decided to file charges against him. Thankfully, this was all caught on video. I know from my experience that the district attorney is always expecting that the client's attorney is going to say that they're protected under the law. So I went out and hired Andrew Bronca, and you did ask about a book to read. I'd highly recommend Andrew Bronca's book, The Law of Self-Defense. He's a phenomenal writer, and if you can take one or a couple of his classes again, he's a phenomenal guy, and he's really good. Even though he's an attorney, he's really good at explaining everything in layman's terms, which I find few attorneys are. But we hired Andrew. All he does is basically consulting on self-defense situations. He reviewed everything. Because I had that money immediately available, I was able to fully hire him and get a report. I had a 119-page report from Andrew stating how it would be an impossibility for the Commonwealth to establish that my client did anything wrong. When I went to the district attorney with that 119-page report, that sealed the deal that the charges were being dismissed against my client. So my client in that situation didn't end up having to go to trial and fight the charges in that way. We were able to get the charges quickly dismissed. So those are some of the benefits of having coverage. I will say there are other ones out there that are good. Firearms legal protection. The only one that I really do not care for and I have concern about is U.S. Law Shield. But again, everyone can make their own decision. I would just caution people to do research about them. They set up subsidiary companies in each state. In Texas, as an example, there's Texas Law Shield. They were sued in Texas over being a scam. I don't know where that lawsuit currently sits, but it was, at least at that time, a class action lawsuit. So again, you want to do your due diligence no matter who it is or what the organization is. Also, be aware of what they're going to cover or what they're not. So as an example, a lot of them, when they just came to fruition, would only cover a firearm. So if you pulled your firearm, you had a catastrophic malfunction, couldn't clear it, you go to your knife, and you end up stabbing the individual, many of them would have disclaimed coverage and said, nope, you didn't use your gun, so we're not on the hook here. I know for a fact that Firearms Legal Protection and USCCA cover any lawful weapon. I have inquired of both of them as to, what happens if there's a dispute over whether the weapon is lawful, and they've said as long as there's no case law directly on point saying this particular weapon type is unlawful, they will not disclaim coverage, and they'll fight the allegation that it is an unlawful weapon. Other provisions to be aware of are alcohol provisions. Again, when many of them came out, and still many of them contain this, it says you can't have any alcohol in your system. Well, what happens if you have a home invasion and you just were having a glass of wine when these perpetrators broke into your home? Some of the policies would disclaim coverage in that. Again, I know USCCA and Firearms Legal Protection both changed their policies in that regard and basically treat it on a basis of as long as you aren't charged with a separate alcohol-related offense, they will not disclaim coverage of it. There are other issues to look to, whether you get to pick the attorney you want to represent you or whether they are going to direct the attorney that you get. I would highly recommend that you be able to choose the attorney you want. Some, like Firearms Legal Protection, do a little bit of a hybrid to that, so they will generally allow you to pick whatever attorney you want, but they want to have an opportunity to vet that person because they are going to deny you if you want your cousin Vinny, who's only ever done contracts, to represent you in a self-defense situational shooting. They're going to say he's not competent, but they're still going to give you the ability to select someone else who has competency. My understanding with USCCA is they pretty much allow you to select whoever you want and figure, hey, if you want to hire your cousin Vinny, who has no experience, it's your life that's on the line. I guess that's your choice. So those are some things to think about. Also, look into whether they provide the money up front or it's a reimbursement program. NRA Carry Guard that came out is pretty much a reimbursement program. They do state that they will provide up to 20% of your max coverage up front. When I previously looked at the terms of the contract they had the person signing, even that 20% was discretionary with them. So to me, it doesn't make a whole lot of sense when for the same cost, a monthly fee, you can have coverage that will pay up front in whatever your max coverage is. So those are some things to really consider. And I can't stress enough about getting to a seminar where you actually learn the laws of self-defense so you know what laws apply here in Pennsylvania or whatever state you may be in so that you know the difference if you're in your home than if you're at the mall. Those can be very distinct scenarios with very different outcomes that you need to know how you can act or cannot act based on those different scenarios and what laws exist in your state.
Thank you. Well, Mr. Prince, I thank you very much for being on the show. Any parting words for our listeners?
Sure, my pleasure. Thanks for having me. My best advice to everyone is make sure that you go out, get proper training, train at multiple different companies and facilities. We have some great ones here in Pennsylvania, like Rockwell Tactical. Please make sure to go out and learn the laws so that you don't unknowingly become the center of a criminal charging because of the fact that you didn't know which laws apply to you.
Thank you. And where can people find you online?
Our main firearms-related site is firearmsindustryconsultinggroup.com. Again, that's firearmsindustryconsultinggroup.com. It's a division of Civil Rights Defense Firm. And our toll-free number is 888-202-9297. Again, that's 888-202-9297.
Well, thank you very much for being on, and look forward to talking to you again soon.
My pleasure. I look forward to it as well, James.
Thanks again for tuning in to episode 57 of the Out of Order Gun Rights Podcast. Please head over to the show notes page, outoforderjameskalita.com/57, and please consider becoming a Patreon for the show. And we'll see you next time.